Welcome to The Productive Attorney, the podcast where we try and make you as a lawyer more productive so that you can do the things outside of law that you want to do. Today we're going to talk about legal writing. I'm going to give you 11 tips on legal writing, and since legal writing is supposed to be concise and brief and logical, I will try and make this as concise and brief and logical as I can. Tip number 1, everybody who has graduated from law school and passed the bar can write legally, can do legal writing. It doesn't matter who you are. If you're able to do the logic side of it, you can do the transactional work and use forms and do all that, or on the brief side, you can do the brief writing. It just takes time and discipline and patience and attention to detail, and that's what you had to have to get through law school. You will have your aha moment when you realize, once you start practicing law, or you've been practicing law for a while, you realize, I can write. I can legally write. Mine was, I was a young associate, and I was given my first appellate brief. It was on a separation of church and state issue. We were the appellees. I was given the assignment. I wrote the brief. It took me 3 weeks to write the brief. 3 days before the brief was due, the attorney came to me and said, when can I have it? When can I see it? And she's very experienced, and I gave it to her, and she looked at it, and I was afraid that she was, not going to like it or was going to change it. And all she did was add one section. She did not change any part of my brief. And this was in the late 80s, early 90s. And when the court of appeals comes back and they issue the opinion in that case, we won, and it was a do not publish. So that meant it would never be published. And what really gave me my aha moment was they took my brief and turned it into their opinion. They used all my cites. They used my language. In fact, I could tell where they edited it. The only thing they took out was the section that the appellate attorney had put in. I never said anything to anybody. I never talked to anybody about, wow, this is great or anything like that. I was just pleased that we had won. But in my mind, that was the moment when I realized, hey, you might be able to write. Tip number two, ask for what you want. So this goes for litigation. When you are writing a brief for litigation, you need to go ahead and do a summary at the very beginning. I didn't start doing this till about 10 years ago, but I think it's really effective. I saw other people doing it, and I said, I have to adopt this. I usually have a summary at the beginning of my motion or a summary at the beginning of my response, and I will say in the very beginning exactly what I want. Plaintiff requests that the court deny defendant's motion for summary judgment. That's it. Or plaintiff requests that the court grant plaintiff's motion to compel and compel defendant to produce categories of documents within 21 days. I mean, that simple. Now, it's been my experience that I believe that judges will often not even read the rest of your brief if they're in your favor. If you're clear and concise, 2 or 3 sentences at most, in your summary of the relief that you request, and they're on your side going in if the other side hasn't met their burden or they believe that that's something that you need. Tip number 3, know your audience. Most of the time in litigation, you're writing to an audience of one, and that's the judge. And you need to know who that specific judge is and what they like and what they don't like, how they operate. You really have to understand that when you're writing your brief. And I always have in my mind a thought of a judge reading my brief on his or her computer in the 15 minutes to a half hour before the hearing gets started. I believe that many judges do that. They might read it the night before, but so many hearings get canceled, so many hearings get postponed, that it doesn't make sense for the judges to read things a week in advance or a week and a half advance unless it's a major issue. So you have to understand and know your judge and know what makes them tick and what makes them work really well one way or the other. That goes on to my tip number 4, and that is be prepared for your work not to be read. There is a frustrating thing in when you spend hours, sometimes days on a brief, and the judge will come in and will give an indication pretty early on that they haven't read anything. I appreciate judges who do that, and there's ways you can kind of trigger that from the judge. So you can say, Your Honor, as you've read in my brief, and judges who are sophisticated will interrupt you and say, "Counselor, don't assume that I've read everything in this case." Other judges are really strong when they come in and they say, calling case number, and they live the case number, and they say, "I have read all the briefs. Is there anything that counsel need to add?" And so as far as your legal writing goes and then your argument goes, it's my way of handling cases is to be ready to be nimble in a courtroom. If you have your brief, you want to have your long outline in case the judge comes in and says they haven't read anything, and you want your short outline in case the judge says that they have read things, and you want questions from the judge, and you want to answer those questions directly. Those are the things that you want in the oral argument, but your brief is the thing that backs it up. Tip number 5 is this: always estimate 2 to 3 times how long it's going to take you than it actually. Let me say that again. You will estimate, okay, I think it's going to take me 2 days to do this brief. Add 2 times or 3 times that. So add 4 days or you're going to take 6 days. A good brief, if you really want to do a good brief, takes you 2 to 3 times longer than you initially think it does. And so if you want it to be really strong, you need to be patient and attention to detail. It's going to take you a long time to get it written. There are some savants out there who can write a brief and get it done in just no time and whip them out. And there are brief banks that big firms use that have been edited, and those are different, right? If you're going to file a motion for summary judgment in a case that's been filed 20 times, that's different. But if you have a unique brief and issues that you've got to bring up, or facts in a case that are going to have to be brought up, it's going to take a lot of time for you to go through depositions. It's going to take a lot of time for you to go through interrogatory responses, to do the legal research and do the follow-up legal research. All these things take time, take energy, take effort, and you have to be ready for it to take longer. That being said, once you go ahead and estimate the time, this is tip number 6, once you go ahead and estimate your time, plan your attack. How are you going to attack your brief? So, for example, if I'm writing a brief, and this goes for transactional too, but if I'm writing a brief, I go ahead and put out specific steps of how I'm going to do it. So, for example, if there's a major summary judgment response that I'm doing, because I'm plaintiff and I do a lot of summary judgment responses, I need to just do specific tasks one at a time. So the first thing I usually do is read the entire file. I go through, we have an electronic system, I'll go through and read everything that's in the file. And I'll even go through and read emails if necessary to find out additional things. But you need to read and know the file. Then I'll prepare a specific outline of what the brief is going to say. Summary judgment response, you have your summary of your argument at the top, and then you have your exhibits and evidence that you're going to introduce, and then you have a paragraph for background, which includes facts and procedural history. Then you have your arguments and authorities, and then you have subsections under your argument authorities, and then a conclusion and a prayer. And you know that's what's going to have in there, but you have to outline that first. Okay, that's what I'm going to do. Those are I'm going to do it. And you have to have your thought process as you go through the outline. Then you do your legal research. Okay, now you've read the whole thing, and I forgot to say you got to read the opposing party's brief if you're responding to it. But then you go ahead and now you do your legal research on the legal issues. Then you go ahead and prepare your factual background, prepare your arguments and authority, and then go back and get your back to your background and get all the evidence together to put together to attach to your brief. Always read the local rules. Check and see in federal court what the judge-specific rules are. And then once you've done all of that and put it together, then you come to my 7th tip. And my 7th tip is proofread, proofread, proofread. There's nothing more unprofessional than having a typo in a brief. It makes it look like you didn't spend the appropriate time on it. There are some typos out there that obviously weren't caught by Microsoft Word, weren't caught some other places. Judges don't look at that. But if there's a blatant typo, when you have Microsoft Word and other editors out there that can catch this stuff right away, that just means you didn't have enough time to work on the brief, and it makes the brief look really bad. The other thing you do with proofreading is you go ahead and you can, as you look through and proofread it, you can go ahead and start to tighten your argument, and eliminate things. I think that goes to my rule number 8, and that is grind your brief. Grind. And that means once you get your brief where you think you have everything, then you grind it. So, and that goes to my 9th rule, which is the 80-20 rule. So you go ahead and you sit down and you just go ahead and rip out that brief. You can get 80% of the brief done once you just get out there. Start typing, make typos if you need to, but get everything down, get your brief done, get the 80-20 rule done, and that means 80% of the stuff you're going to get done in 20% of the time. So you're going to get 80% of the brief done, all the standard of argument, the background, the legal authorities, all that. You're going to get 80% of that done just by whipping it out and typing it out. But then come back to the rule I talked about, and that's just grind. On that brief that I did 30 years ago for the appellate court, I went over every word. I made sure that every word had meaning. I made sure that it was just so tight, and I eliminated as much as I could. When I'm saying grind, that means the opposite of adding. That's subtracting from the brief. Anything that doesn't go towards the heart of your argument, anything that doesn't make your point, that you're just throwing in there just to throw in, needs to come out. Because the moment the judge starts to lose interest in your brief, starts to lose interest in your case, they'll stop reading. Judges will just stop reading. They get tired, and they don't want to read a bad brief. So grind, which goes to my rule number 10, which is always leave yourself an extra day. When you have a heavy brief, I always like to have it completely done, like ready to file, the day before it's going to be filed. I like to sleep on it, just go home, have a relaxing evening, go do a workout, come back in the morning, and when I get there in the morning, relaxed and refreshed, hit it again, hit it one more time. And when you come back and look at it fresh, you'll see obvious things that need to be moved, changed, other things that need to be done. So my tip is always leave yourself an extra day. And then the 11th tip is more technical tips. The ABA and everyone else that says these things says use Oxford commas, and that is the comma between when you have three different subjects and you say 2, 3, and 4. Do you put a comma after the word 3? That's an Oxford comma. And most places say you do. It's not required, but do that. Second is avoid the passive voice. Use the active voice. And when you go through a brief, you'll know when you're using passive and you use active. Use strong headings. I think there's nothing worse in a brief than 4 pages with no headings. It just goes on and on and on. You have to have headings so that the court signposts so the court can see what's going on. If you have 4 pages of just run-on stuff, it loses its effectiveness. You should be able to put the information in a page or at most 2. Spacing is important. Don't try and jam all your stuff in there. I like to have both sides, right and left, justified. I like to have it to be a very, very cut off point, but it's not required that you have it cut off completely. But I like the right and left side justification. Footnotes or cites in a brief. So if you're citing authority, do you put a footnote in, or do you go ahead and put cites in the actual brief? I go back and forth on that. It really depends on the brief for me. And I also look at the judge, especially in federal court. If I see judges in federal court, when they do their opinions, that they use footnotes, I'm going to do footnotes. If I look in their opinions and they put cites in the body of their opinion, I'm going to put cites in the body of my opinion. I'm going to match what the judge is going to do. In state court, that's not so much. I think in cases where the authority is not as important, I will go ahead and put it as a footnote. But in cases where I really want to emphasize the authority, I will put it all in the body of the brief. Another tip, that's part of the 11th in grinding. Don't insult opposing counsel in your brief. I think I've seen that happen before, and there's nothing that gets judges more upset than you insulting opposing counsel. Look, if you feel that strongly about what opposing counsel has done in a case, file your motion for sanctions. Don't go ahead and trash them in a brief where you're trying to make legal arguments and you're trying to win on the legal side. The court hates that. They look at that as just, that's not helping them make their decision. And that also goes with big words and words that are kind of doing that, attacking opposing counsel or attacking the argument in a really bad and negative way. Spurious is a word that I've seen used before. They use words for lying, all different kinds of words just to say that the opposing counsel is lying in what they're saying. All those things really turn judges off. If you have to resort to the insulting the opposing counsel to win your argument, and if the judge sees that, they're like, really? They can't win on the facts, they can't win on the law, so they're gonna insult opposing counsel. I think that's horrible. Don't do that. And take out those adjectives where you try and really improve the case by exaggerating a particular fact or by using big words to try and impress. Big words don't impress judges. What impresses judges, what makes judges happy, is very concise, very brief briefs. That's why it's called a brief. If you can say something in 3 pages instead of 5, say it in 3. I've had responses that are 2 pages long. Have a 1-word summary of what I want and 2 pages. I recently filed a brief in federal court that I think was 4 pages, and the court immediately granted it. It was a substantive brief too. So just go ahead and don't use those big words. Don't try and press anybody. Judges really don't have time to do it. I'll tell one last story and then let everybody go. I am, as a law school teacher, I give exams, and in the advanced torts, I give a final exam, and I have over 50 students in my class, and I told them, treat me like a judge when you're writing your final. If I see that you're just putting junk in there, it's going to hurt you. I'm a practicing attorney. I don't have time to read a bunch of garbage that you're all throwing on the paper. I want you to get to the point, identify the issue, answer the question that's asked, and move on. You don't need to overemphasize, write too much in it. It's gonna bother me. And I told him that, imagine that I'm only going to read your exam for 15 minutes. You can put as much words as you want in there, but I'm only going to read for 15 minutes. So how are you going to impress me in those 15 minutes? And so that's the way I try to teach them how there's no word limit, but there really is a word limit. You need to be really careful. That's my advice on legal writing. I really do, when a good brief is done. I forgot one other tip. It's kind of 11A. When you're done with your brief, there are professional tools out there that you can use to edit your brief one last time. I always like to come in and bring a professional tool. So Microsoft has just an editor that's good. The Microsoft editor, if you look up on your bar, it's usually on the right-hand side, and it says editor. If you do that, it'll work on grammar mistakes, spelling mistakes, that sort of thing. There's another one that I use called WordRake, WORDRAKE. WordRake is an amazing tool. It is like the Microsoft editor, but it's kind of on steroids and for legal. And I've used that on major briefs. I'll bring it in and just run it through the brief. And it's amazing what those things catch and how they can do the grinding for you, help you find that information. So those are my tips on legal writing. Hope you have a great week. Goodbye.